Thank you, Mr. Chairman, Ranking Member Schakowsky, for organizing today's important hearing. You know, like many of my colleagues on the dais, I'm disappointed that we failed to pass the American Data Privacy and Protection Act in the full House last Congress. And I urge my colleagues, particularly those who are new to the committee, to continue working in a bipartisan way to pass a comprehensive privacy law that meets the needs of the families we represent. Mr. Chairman, the federal laws that govern our privacy today in March of 2023 are the same ones that were in place when we had a hearing on holding big tech accountable a year ago in March 2022. They're the same laws that were on the books when the CEOs of Google, Meta, and Twitter testified before this same committee a year prior to that in March 21. In fact, they're the same laws that for decades have permitted companies to harvest our sensitive data. Things like medical symptoms that we look up on a search engine, or our location that paints a picture of where we work, where we send our kids to school, and where we pray, and sell that data to third parties or use it in ways that are contrary to what any of us would reasonably expect. Many of us have been sounding the alarm about this for a while. In the past 2 years, I've sent inquiries to phone and messaging apps asking about the misuse and sale of messaging metadata, to data brokers about the sale of geolocation data, and to online gaming companies about their treatment of data collected on our teens. These companies can and should be doing better, but without comprehensive privacy legislation like ADPPA, they won't act. And it doesn't stop there. One type of product I want to highlight, the desperate need for an update, is education technology. According to a 2021 study from Center for Democracy and Technology, 85% of teachers and 74% of parents believe EdTech is very important to students' education, and more teachers are becoming aware of the need to thoughtfully consider students' privacy. However, a majority of parents still have concerns about student privacy, and a significant number of teachers still have not had training on privacy policies and procedures. So, Ms. Givens, with the Family Educational Rights and Privacy Act, or FERPA, having passed nearly a half century ago, back in 1974, and still being the law of the land when it comes to student data, can you describe to what extent companies that offer EdTech software are or are not covered by FERPA?
Thank you for the question and for citing our report. We spend a lot of time with educators, teachers in the classroom, as well as students and their families, and so we see firsthand the level of concern about how kids' data is being used in this environment. To answer your question, FERPA applies to personal information from education records that are maintained by covered entities. That basically means public K through 12 schools, colleges, and universities that accept federal student aid. When EdTech software vendors work with those covered entities, they have to comply with FERPA. But really importantly, FERPA falls short in all of the other ways in which EdTech vendors might be engaging and receiving information about students. So first, it doesn't contemplate harms that might result from other types of information, like when the vendor interacts directly with the student and gathers that type of record. Second, FERPA doesn't address any of the civil rights issues that can stem from algorithmic harms, as we're seeing increasing use of AI systems deployed in education settings. And third, FERPA's enforcement mechanisms fall directly on schools and not on the vendors, and the punishments are draconian. You lose your federal funding. We need the burden for privacy compliance to sit not just with the schools, which are so overwhelmed, but with vendors in this space as well. And so complementing FERPA with strong, comprehensive privacy protections for those commercial uses of this technology is really important as well.
Thank you. In some cases, EdTech software, as you mentioned, not offered through business-to-school contracts. Instead, they may be a free online game or an educational app. And the data collected while on these sites or apps can later be used to target ads or sold to third parties, particularly on our students who are under the age of who are 13 and older. So the idea of consent gets murky, as you mentioned, when we are talking about a student or their parents deciding between participating in class while being tracked versus not participating at all. Can you speak to how the duty of loyalty and data minimization and ADPA would be applied to these types of sites and apps?
You're exactly right. So FERPA only applies to vendors when they're processing education records, which doesn't include any of the many other ways that students are interacting with technology today. I think about the experience with my own children, and they download apps not going through those official channels. They're sharing a lot of information, and they're doing it to be able to have an educational experience. Again, this shows why notice and consent is broken as a model, because there isn't a question of consent. You want to be able to access these platforms. Yep. And sadly, COPPA is falling short here too, although of course it does offer some protections to services targeting children under the age of 13. That too essentially rests on a notice and consent regime that is really hard to operationalize in practice. So that's why we need the broader comprehensive privacy protection, is to regulate those additional uses and create baseline protections for students.
Thank you. Thank you so much for your testimony. I yield back.